Good afternoon, and welcome to the New York City Committee on Civil and Human Rights. At this time, please place your phone on vibrate or on silent mode. If you want to submit testimony, send it to testimony@council.nyc.gov. Once again, that's testimony@council.nyc.gov. At any time during this hearing, do not approach the dais. Thank you for your cooperation. Chair, we are ready to begin.
Thank you. Good afternoon, everyone. My name is Natasha Williams, and I serve as chair to the Committee on Civil and Human Rights. Today, we'll be discussing the recent expansions of New York City's human rights law, or NYC HRL, with regard to employment protections against workforce discrimination. Since 2021, there have been several notable changes to the city's human rights law, including the passage of Local Law 4 of 2021, which prohibits discrimination based on a person's arrest record, pending criminal accusations or criminal convictions, Local Law 88 of 2021, which extends employment protections to domestic workers, Local Law 32 of 2022, which prohibits employers from posting job listings without minimum and maximum salary information for positions located within New York City, and Local Law 31 of 2023, which expands the definition of victim of domestic violence to include economic abuse, thereby also extending the employment protections within the NYC HRL to these victims. While it is important for us to work toward increasing protections for New Yorkers where we can, it is just as important to discuss the impact of these new laws after they have taken effect. We'll also be hearing several bills today that further expand protections against workforce discrimination. Intro number 84, sponsored by Public Advocate Williams, would require employers to hold an onboarding meeting to discuss an employee's reintegration back into the workforce after parental leave. Intro number 422, sponsored by Councilmember Rivera, would require covered entities to maintain a record of requests from persons requesting a reasonable accommodation. Intro number 811, sponsored by Councilmember Gennaro, would void no rehire provisions in settlement agreements for persons aggrieved by unlawful discriminatory practices. Intro 812, also sponsored by Councilmember Gennaro, would extend the statute of limitations for commencing a private cause of action under the city human rights law. Lastly, intro number 864, sponsored by Councilmember Ressler, would forbid agreements to shorten the period in which claims and complaints of unlawful discriminatory practices, harassment, or violence may be filed and in which civil actions may be commenced. Before we begin, I would like to thank everyone that has joined us today, and I look forward to hearing any testimony on recent expansions of the New York City human rights law or bills being heard today. I'll now turn it over to Councilmember Gennaro for remarks on his bill, and I also want to acknowledge that we are also joined by Councilmember Salamanca.
Thank you, Madam Chair. Thanks for holding this hearing. Thanks for hearing these bills. Let me take one more sip. I am proud to be the sponsor of two bills being heard today. Intros 811 and 812 fill important gaps in our city's policies, particularly aimed at safeguarding workers against discrimination and employer retaliation. 811 would prevent any future no rehire provisions and sets an expiration timeline of 5 years for current no hire provisions. Too often, no hire provisions are used to automatically disqualify persons from future employment opportunities for coming forward with complaints about workplace harassment. By getting rid of this practice, we empower employees to voice legitimate concerns without the fear of being unjustly blacklisted within their chosen professions. Intro 812 would extend the statute of limitations from 3 years to 6 years for civil actions by persons who are discriminated against. Victims of abuse are often afraid to come forward or are not aware that their rights have been violated. By moving forward the statute of limitations, that is pushing it out further, we provide victims with greater opportunity to report instances of discrimination and uphold the fundamental principles of human rights. And once again, I thank you, Madam Chair, for bringing these bills forward. I look forward to the administration's good testimony on these items.
Thank you, Councilmember Gennaro. I want to acknowledge that Councilmember Rita Joseph has just joined us and turn it over to Councilmember Ressler for remarks on his bill.
Thank you so much, Chair Williams. We are incredibly fortunate to have you leading this committee and just serving in the council altogether. So thank you. It's always good to see you. And thank you to CCHR for joining us. And really want to just express gratitude again to the chair for the opportunity for a hearing on our bill, Intro 864. No one should ever have to deal with harassment or discrimination at work. But when these unfortunate incidents occur, New York City workers should be able to rely on a strong city human rights law that protects them in court. But what many large employers are doing is forcing those employees to sign contracts that undermine and limit their rights. Under city human rights law, employees currently have 3 years to file claims for discrimination, harassment, violence. Employees, though, too many employees have been unknowingly signing contracts, sometimes even during the application process, that shorten the statute of limitations to a matter of months. Some of the largest employers in New York have done this: Northwell Health, FedEx, Raymore and Flanigan, just to name a few. And I want to compliment my friend, Councilmember Gennaro, for his legislation that it would extend that statute of limitations from 3 to 6 years, which is the right thing to do. These contracts are unreasonable and contrary to public policy. 6 months is just not enough time for aggrieved workers to recover, find a lawyer, and file a claim, especially given the high likelihood of the threat of retaliation, which discourages many employees from immediately filing claims. Intro 864 will restore the intent of our strong human rights law and ensure no private employers can create their own loopholes. Every employee should have a full 3 years or 6 years to file a claim. Some state courts have already taken this step, including our friends across the river in New Jersey. That's the first time I've ever said something nice about New Jersey. We need to catch up. I especially want to thank a constituent of mine, Ann Clark, who is a brilliant employment law attorney, who reached out to us to suggest that we introduce this legislation. I want to thank her for her guidance on this matter, and each of our co-sponsors, including our chair, and just say this: I'm really proud of as I know CCHR is, of our landmark human rights law. It is a model for the country. Yet if we allow private employers to undermine it and find loopholes in it, we do ourselves a tremendous disservice to protecting the people of New York City. And I hope that we can get Intro 864 passed as quickly as possible to ensure that New Yorkers have the protections that they deserve. Thank you.
Thank you, and now I'll turn it over to Committee Counsel.
Thank you, Chair Williams. Good afternoon, everyone, and welcome. My name is Jace Regan-Apathy, and I am counsel to the Committee on Civil and Human Rights. Before we begin testimony today, I would like to remind everyone that is joining us via Zoom that you will be on mute until you are called on to testify. I will be calling on public witnesses to testify after the administration's testimony and council member questions. So please listen carefully for your name at that time. Council members, you will be called on to test for questions after the full panel has completed their testimony, and you will be called on in the order you let us know you have questions. Please note that for the purposes of this hearing, we will be allowing for a second round of questions. For public witnesses, once your name is called, if you're joining via Zoom, a member of our staff will unmute you, and the Sergeant at Arms will give you the cue to begin. If you are attending in person, please listen carefully for your name, and when it is called, you can come up to the table and begin testimony when everyone is situated. We are now going to proceed with administration testimony. We'll be hearing from the Commission on Human Rights, and at this time I will administer the affirmation. Panelists, can you please raise your right hands? Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and respond honestly to council member questions?
I do.
I do. Thank you. At this time, I'd like to invite Deputy Commissioner Kemma Ford to present your testimony.
Thank you, and good afternoon, Chair Williams, council members, committee staff, and members of the public. I'm Joanne Kemma Ford, Deputy Commissioner of Policy and External Affairs at the New York City Commission on Human Rights. And joining me today for questions is Hillary Scrivani, Senior Policy Counsel. Thank you for convening today's hearing on employment discrimination. I'm just going to start by sharing a very brief overview of the City Human Rights Law and then turn to the 5 amendments on today's agenda. Our agency, the Commission on Human Rights, enforces the New York City Human Rights Law, which prohibits discrimination in the areas of employment, housing, and places of public accommodation. Today, the law includes 27 protected categories, which include age, gender, sexual orientation, gender identity, religion, disability, race, and national origin. That number will grow this fall with the addition of height and weight as protected categories. As the chair mentioned, since the start of fiscal year 22, 5 amendments to the Human Rights Law's employment protections have either taken effect or been signed into law. The chair went over those, so I'm not going to repeat the list again, but they're in our written testimony. To fulfill the Commission's dual mandate of enforcement and fostering intergroup relations, the Commission's 2 largest units are the Community Relations and Law Enforcement Bureaus. The work of these units is detailed in the written testimony, and since we've discussed it with Council on a number of occasions, recently at our budget hearing, we are not going to go through that in detail. But I think just as a refresher, the Community Relations Bureau sits at the center of our prevention efforts and is responsible for education, outreach, and training. The Law Enforcement Bureau conducts testing, initiates complaints, and engages in litigation. Individuals in New York who believe they've experienced discrimination or harassment in violation of the Human Rights Law and want to seek remedies have 2 paths. 1, they can report discrimination directly to CCHR's Law Enforcement Bureau and seek resolution at the Commission. 2, they can file a complaint in court. When a case is filed directly in court, the Commission is not involved and the case moves forward in the judicial system. Cases that are investigated by the Law Enforcement Bureau can be resolved in several ways. A conciliation agreement, a settlement agreement made between the Commission and a covered entity to resolve claims under the city's human rights law is one way. These settlements can include damages, civil penalties, and affirmative relief, such as policy changes. Matters that are not settled or mediated may be referred for an administrative trial and hearing. For cases that are filed in courts, the resolution falls outside the purview of the Commission, but judicial orders or settlements are potential outcomes in those court cases. In fiscal year 22, the largest number of inquiries received by the Commission were in the areas of employment. I will briefly note the current protections in employment before turning to the bills. So under the City Human Rights Law, employees in New York have the right to a workplace free from discrimination and harassment, which includes gender-based harassment. Notable for today's bills, the Human Rights Law also requires employers to provide reasonable accommodations based on 4 protected classes. First, disability. Second, pregnancy, childbirth, and related medical conditions, which includes lactation. Third, religion. And fourth, status as a victim of domestic violence, sexual assault, or stalking. And each of these categories are defined in the Human Rights Law. The Commission has long been committed to equity in the workplace and preventing discrimination, and I'll turn now to the proposed bills. Intro 422 requires covered employers to maintain records of reasonable accommodation requests that are made in writing by employees. Currently, the Human Rights Law requires that if an employer learns, either directly or indirectly, that an individual requires a reasonable accommodation, the entity has an affirmative obligation to engage in a cooperative dialogue and provide a determination in writing. This bill would apply to all requests for workplace reasonable accommodations covered by the Human Rights Law, again, which are received in writing. The administration supports the intent of the bill to preserve documentation regarding requests and resolution of reasonable accommodation requests consistent with the Americans with Disabilities Act and other relevant laws. Intro 812 would extend the time period that employees have to file complaints in court alleging discrimination to 6 years. And as the councilman already mentioned, it's currently 3 years. The administration looks forward to discussing with council about how to balance the interests of redressing discrimination and the interests represented in the current statute of limitations period. Intro 811 would prohibit and void no rehire provisions in mediation and conciliation agreements between employers and the Commission, and in settlement agreements between private parties in state or federal court. The administration supports the goal of protecting New Yorkers from unfair or retaliatory agreements that limit their future opportunities, and looks forward to discussions with Council about how to balance this goal with legitimate interests that may lead to no rehire provisions to resolve workplace disputes. Intro 864 would render unenforceable and void any and all agreements that shorten the statute of limitations for filing a case with the Commission or filing a complaint in court. The administration supports the intent of this bill to prevent covered entities from using coercive contract terms that limit the time frame in which potential aggrieved parties can seek redress for violations of the human rights law consistent with contract principles. Lastly, Intro 84 would require employers to hold an onboarding meeting for employees returning from parental leave to discuss the conditions and expectations of employment following the employee's return to work. Employers would be required to keep records of each meeting for 5 years. Intro 84 charges the Commission with issuing guidelines for such meetings, including the timeline, topic, relevant rights and responsibilities, goals, and duration. The administration supports the aim of ensuring that employees returning to work from leave know what rights and protections they have, and the Law Department is reviewing the structure contemplated in this bill. Consistent with the human rights law, CCHR has previously crafted guidance about legal protections for pregnant workers and has developed a model lactation policy. CCHR has also developed a fact sheet on anti-discrimination protections for individuals with caregiver responsibilities, which explains that individuals with caregiving responsibilities cannot be treated differently than others in the workplace. Individuals may take leave for a variety of reasons, and workplaces may have different obligations relating to the basis of the leave, as well as depending on the size of the workplace and any relevant internal leave policies, among other factors. The Commission does not administer any parental or other leave laws or enforce employer application of parental leave. Generally, provisions of parental leave in New York City workplaces stem from federal and state laws, as well as voluntary employer policies. We look forward to learning more about the intended impact of these bills and to working with Council and the public advocate and sibling agencies to achieve the goal of ensuring all employees have awareness of workplace rights. In closing, the Commission is committed to preventing and combating employment discrimination in New York City and ensuring individuals who experience discrimination and harassment have a venue for redress. We appreciate the Council's attention and commitment to addressing these issues, and we welcome your questions.
Thank you. I'll start with some questions around laws that are currently active, have been enacted. And so Local Law 4 of 2021, this bill was enacted on January 10th, 2021, and prohibits discrimination based on arrest record, pending criminal accusations or criminal convictions. Prior to the enactment of this law, how often was CCHR receiving complaints or inquiries about the discrimination that this law targeted?
Thank you for the question. Prior to the enactment of Local Law 4, there were already fair chance protections that were expanded through Local Law 4, as well as a preceding change to state executive law. I think we have seen very consistent numbers of complaints over time before the passage of Local Law 4, as well as following. What has changed, I would say, in the wake of the amendment to the Fair Chance Act is that our testing went up significantly, and the number of inquiries we received has also gone up. I think the changes are nuanced and require a knowledge of criminal law, and as well as your own background, which is not always, the conviction histories are convoluted, and it's not always clear what posture someone's criminal history might be in. But I would say even before the change in local law 2, this has been a significant priority for our agency. Prior to local law 4, we had done a campaign, criminal record, you can work with that. In the wake of local law 4, we have upped our trainings with employers. So this is included in our general human rights law training, but we also have a specific fair chance training. We have legal guidance in this area, which was significantly updated after the passage of local law 4, along with FAQs for employees and employers that really attempt to break down the coverage of the Fair Chance Act. And we have an annual symposium with legal service providers and impacted individuals on the fair chance. The last one was in October.
Are you able to provide a number of inquiries since the law went into effect?
I have the inquiries for the past few years. It's around 800 inquiries on this topic. That's actually 2022 through 2022. We don't have our fiscal year 23 numbers, but they are forthcoming soon.
Okay. And in terms of formal investigations or complaints in relation to these inquiries, have any been launched, and have any of these cases been resolved thus far?
Yes, so we've had individual claims in this area as well as commission-initiated complaints in this area, and we also have a number of settlements, recent settlements, and some going back a little bit to 2021, 2022. In a lot of the cases that we see around fair chance, even though the law has been in place for quite some time, it's actually, the violations are still at the job advertisement and application phase. But we also have a number of settlements with prominent New York City employers where we've identified either illegal questions during an interview process or illegal application questions. And when we are able to settle those cases, we include not only training on the human rights law for leadership, but also for people that engage in interviews. We have in at least 2 to 3 cases that I know of also, as terms of settlement, had the employers work directly with reentry organizations to create an employment pipeline for individuals that are returning to their communities. And I think that's what I was going to say. Changing their policies, obviously, and changing their applications. And some entities report back to us on compliance and what they're seeing in terms of numbers.
Okay, last question on local law 4. What challenges has your agency faced when enforcing this law?
So I think I like to say that it's actually a success story because we've done a ton of outreach and training. We've had a fair number of very successful settlements in this area, and I'm happy to send them to you all after the hearing. I think the challenges with fair chance are what I foreshadowed a moment ago. It's extremely complex area of law. We get not only a high number of inquiries, but also just a lot of calls from HR departments, employers, and individuals asking sometimes very nuanced questions about their rights and obligations, and often we refer those individuals to legal service providers. I should also flag, we are updating our rules in this area, and there will be a chance for all interested stakeholders then to provide comments to CCHR so that we can clarify our own rules and help all the stakeholders understand this area of law.
Okay, now I'll turn to local law 88, which extended employment protections to domestic workers. Prior to the enactment of the law, how often was CCHR receiving complaints on inquiries about discrimination that this law targeted? And it'll be repetitive with the same lines of questions, which just also wanted to know if you received any inquiries regarding compliance of the protections extended to domestic workers. If so, how many inquiries were received? And same question, if you launched any formal investigations or complaints in relation to these inquiries. Same question around like training and outreach and challenges you faced with the law.
Thank you. Okay, so I'll try to answer all of them and see how.
I can ask them again.
See
but
how
I just
do.
wanted to like get you like because
No.
we're gonna do the same thing for Local Law 32 and Local Law 31, and then I'll stop and let colleagues ask questions about legislation. I know the bill sponsors are here.
Okay, great. So I think as folks in this room know, and certainly council, the domestic workers protections were really started by and pushed by advocates, National Domestic Workers Alliance, Hand in Hand, Adhikar, and others across New York City, and we worked very closely with advocates in the lead up to the implementation date to develop materials like a brochure that explain and are accessible to individuals who may not be sitting at a computer all the time to understand their workplace rights. We did a citywide campaign on domestic worker protections, and we definitely saw education and awareness raising as pivotal in this particular space. I think we see it for all of areas of our law, but for domestic workers, you are often working in someone's home. It may be a very personal relationship, and we understood that we needed to get to employers, and so we did a lot of outreach, in particular to employer groups, and I also mean like parent groups, to find individuals who are most prevalently hiring domestic workers covered by our law. So here as well, we have a specific training that's in English and Spanish that we've delivered, I think in fiscal year 22 to around 800 people. It's also part of our general human rights law training, which reaches thousands of people every year, and that training is in English, Spanish, Mandarin, Bengali, and Urdu. I think on the question of complaints and inquiries, we had a few complaints, I think around 2 prior to the enactment of this law. I don't have the number of inquiries with me from prior to March 22, but I can get that to you in follow-up. We, to my knowledge, have no inquiries or complaints in this area to date. I would also add to that we're not hugely surprised by that outcome, and maybe that's a segue into the question about challenges. I think we all knew in the lead up to implementation of this law that domestic workers are often in a sensitive workplace environment. You might rely on your employer for word of mouth for your next job. It's often individuals who may be in a financially precarious situation or not want to discuss immigration status. And while we don't ask anyone about their immigration status, it is a concern of people when they're coming to any government agency for any service. So that said, outreach and partnership with some of the organizations that I mentioned at the top has been critical, and we have in our Community Relations Bureau a lead advisor on domestic and low-wage workers who is really building and maintaining the partnerships with some of these advocates. And then the last thing I'll say just on this front is that DCWP, our sibling agency, also has jurisdiction over domestic workers' wage and hour claims, and they launched, I think earlier this year, a mediation program, and so we're in conversation with DCWP to make sure that if any discrimination claims arise in the cases that they're seeing, we have a pathway for our law enforcement bureaus to be in touch with each other.
Thank you. Have you spoken to the advocates that you worked with originally in passing the law to see what they're seeing on the grounds? Yeah,
I think a lot, and I have not been personally talking to all the advocates, but our lead advisor has been. I think a lot of the push, and we've seen this with other changes to our law, is about changing a workplace culture and also putting employers on notice of the rights of employees. I imagine this is an area where there might be more comfort over time reporting instances of discrimination in domestic workplaces, and so we will be watching that, and we will be staying in touch with the advocates who are also usually invested in lots of other areas of our law as well.
Thank you. Okay, now local law 32, the salary transparency law that we enacted last year prohibits employers from posting job listings without minimum and maximum salary information. We've seen a lot of interesting news articles. In fact, someone sent me a news article this morning, a New York Times article talking about Netflix, I think, that had very, very large ranges, which undermines the intent of the law. And so, similar questions. Have you received more inquiries regarding job listings without the salary information since Local Law 32 took effect?
Thank you, Chair Williams. And I would like to echo Deputy Commissioner Camaford and saying thank you for having us here today. So I will also, take a crack at hitting on all the questions, and, please let me know if I've missed anything. So as the CCHR stated in our testimony, education and outreach is a key priority and function of the Commission. And we have been very active in pay transparency area since it took effect in November of 2022. The Law Enforcement Bureau has conducted testing. The policy and communications team, through communications, we launched the Display the Pay campaign, which was a multifaceted digital campaign. And we have led multiple trainings on pay transparency. It is now included in all of the Commission's employment discrimination trainings. In addition, we have released a fact sheet that is translated into multiple languages, including the breakdown of pay transparency, so the covered employers and members of the public can be aware of their rights, obligations. As far as enforcement, we have received hundreds of inquiries since this law took effect, and currently we expect to be filing formal complaints within the coming months.
Thank you. This kind of touches on what I just mentioned about the overbroad salary ranges. Have you received any inquiries around that?
I don't have the specific breakdown of the nature of the inquiries. I mean, I will say that the good faith pay range requirement is, a key part of the law, and certainly in my experience in trainings, we receive a lot of questions on that issue, but I don't have the, that underlying data of what the nature of the inquiries are, but I also, invite Deputy Commissioner Ward to weigh in if she has anything additional to say on that.
Yeah, and just if you have like a number of complaints that you've received since the law was enacted.
Yeah, so we don't have the fiscal year 23 numbers yet because they're finalized soon, and then in our annual report in September. But I think as Ms. Scrivani mentioned, we understand the Law Enforcement Bureau, which is not us, will be filing complaints based on inquiries and tips.
Are you able to give like a rough estimate? Like, are people reaching out to you about this? Because, for instance, with the domestic worker protections, pretty much no one has really inquired at all. So I know you are waiting for official numbers, but do you have a sense, like, are people actually reaching out to you when they're seeing things?
Oh, sorry. Absolutely, yes. So we've received hundreds of inquiries on this law.
Great. I look forward to receiving the official numbers when they come out. Last, but certainly not least, and I know we recently enacted this, so I'm pretty sure you may not have as much information on Local Law 31, which expanded the definition of victim of domestic violence to include economic abuse. Prior to the enactment of this law, did your agency receive complaints and inquiries around this type of discrimination?
Prior to the enactment of this law, since this law was not in effect, our numbers wouldn't reflect the specific nature of the the nature of the domestic violence, just whether somebody was making a complaint in that area. I can say with this law taking effect next week, we have been ramping up our outreach and education efforts, making sure the public and covered entities know about their new rights and obligations. Our communications team is preparing a social media campaign. We are also collaborating with our sibling agency, NGBV. We have kind of a weekly video that we put out on social media called the Human Rights Minute, where we cover different areas of our law, and this has been covered recently. We're also updating our fact sheets, educational materials, preparing to have that available in translations, and then also speaking with advocates and stakeholders in the preparation of these materials. And we also have and these protections are also included in our employment discrimination trainings.
Yeah, and here I'm talking to our future selves, but one thing I think that we will see in this space with the expanded definition of domestic violence is that it will probably be some time before the complaints reflect even the outreach and education that we're doing, right? It's, in this situation, it's individuals who have experienced economic coercion and then experienced discrimination in housing or public accommodations or employment. So it's I think, a compounded form of trauma that will impact what we see from a law enforcement perspective.
Thank you. So do you anticipate any difficulties with enforcement of this law? I gather it's not tricky for people who are dealing with it, but it is sort of a different type of way of looking at domestic violence than we have in the past. So I gather that will take some level of educating, but do you foresee any other difficulties?
Yeah, I would just like to highlight, what Deputy Commissioner Cama-Ford was pointing out, just that individuals are only able to file complaints if they, or at least our law would only come into play if they're experiencing discrimination in employment and in housing on the basis of economic abuse. So there are just challenges by how the law is written and when it can come into play. Obviously, people dealing with these issues have a wide, a wide variety of concerns and needs. So just when this law can actually, when their rights are violated under the law, is going to be in very limited circumstances.
And I think, that is one of the reasons that having service providers and the justice centers and NGBV and others who are really frontline interfacing with survivors or those who are experiencing intimate partner violence know and counsel individuals if it makes sense to file a complaint. As I was saying earlier, that's one metric of how we measure our success, but because it takes a lot for individuals to come forward and file a complaint, even though we endeavor to make it as easy as possible, it's not always reflecting the actual trends in communities.
Thanks. One last question, just to go back to Local Law 32. Are you having any challenges with enforcing that law?
So for pay transparency, I would say one challenge is that it applies to employers of all different sizes. It applies to your corner bodega. It applies to Google. So making sure that all employers who are covered by the law are aware of these. And one way the commission has been approaching this potential issue is by doing trainings that specialize for different size employer groups. For example, we did a training with the Small Business Services Association, and we have also done trainings with smaller employer groups to just make sure the word is out there and everybody knows, even if you're posting a handwritten sign in your shop, advertising a job, you're covered by this law.
And just one thing I'll add to that is that I think we will have a better sense of what the trends are over more time, right? Right now we're going through the inquiries to evaluate. There's also a similar state law going into effect in not too long, and so we'll see how that impacts. I think we're reading the same articles as you, and we'll have more to say from our law enforcement bureau, maybe next year. I'm not going to overpromise.
Thank you. With that, I'll hold off on the rest of my questions to let some of the bill sponsors ask questions. And with that, I will turn it over to Councilmember Gennaro for questions.
Thank you. Thank you, Madam Chair. This is not going to be very pleasant. We got two bills here, 811 and 812, and this is supposed to be a public hearing where the administration is supposed to come forward and indicate what the position is on a bill, and you haven't done that. We got the members here, we got the chair here, we got people here, we got people on television. This is being streamed, and you have the audacity to come in and give me one sentence on each bill that doesn't even say anything? So I have to spend my 5 minutes asking you what your one sentence means. And so, you indicate for 812, the administration looks forward to discussions with the council about how to balance the interests of redressing discrimination and the interests represented in the current limitation period. Okay, so you mentioned the interests represented. So, ordinarily, if this were not, this is completely non-responsive, in my opinion. This is lazy testimony, in my opinion. No one knows what the administration thinks about these bills. This is why we have these hearings. You're the Commissioner on Human Rights. We have a right to know what the administration thinks about these bills, and we call you here today, and you didn't give that to us. And so I want to register, whoever's here from the mayor's office, I want to talk afterwards, because this is not the way this is supposed to work. I've been a council member for 12 years, or 14 years, a staff member for 12 years before that. I've never seen such non-responsive testimony. And so I don't even know where to go here. And so, in both 812 and 811, you talk about so-called legitimate interests that are, represented with the status quo. Why don't you talk about that?
So I will start with 812. And just to begin with the fact that we are committed to ensuring the ability of individuals to seek and receive adequate redress when they face discrimination. There are a whole host of state and federal laws that set out statute of limitations for discrimination. And
which you could have talked about in your testimony, but you chose not to do that. That's what your testimony is for. We should have read that. Instead, you just said, interest representatives, now I have to go through my time, having you, to pull out of you that which should have been in your statement. But go ahead.
I hear what you're saying.
Please, yes. Please proceed.
I think generally speaking, the ability to effectively investigate and document allegations of discrimination dissipate over time. That's part of the reason statute of limitations have been set where they are. We, like you, are interested in hearing from stakeholders. We are not experts on all of the statute of limitations that exists for bringing discrimination claims. We are experts on the human rights law, but we want to ensure, as we always do, that the human rights law changes are clear and they allow for the redress that people are seeking. If employers or even individuals experiencing discrimination have one statute of limitations under the human rights law and others under other laws, that could be confusing. We want to hear also from the members of the public before we develop a final position on this bill. So I will turn to 811, which would prohibit and void no rehire provisions in mediation and conciliation agreements between employers and the commission, and in settlement agreements between private parties in state or federal courts. So this is both a forward-looking bill, but also has retroactive provisions. We, with the law department, are still reviewing the bill, and as I said in the testimony, we want to protect New Yorkers from unfair or retaliatory agreements that limit their future opportunities. We understand that there are instances where it may be appropriate for employers to have no rehire provisions. We understand that may be the case in disciplinary proceedings or where there's workplace misconduct. I think those are separate and apart from no rehire provisions in a discrimination settlement, which I will note is something that we as the commission, we do not have provisions like that. So this law covers a lot of agreements, including by private parties. We want to make sure that we're balancing state, federal law, contract law, constitutional protections as we determine the administration position.
Thank you, and it is my position that everything you just said, could have been included in the testimony that you put forward. This is what people are supposed to do when they get ready for hearings. They're supposed to, all that you just went through could have been part of your statement, but instead you just chose to say, we'll talk about it. And so, I didn't have any of the backstory. That's what your prepared testimony is for. I'm finished with these witnesses. Thank you, Madam Chair.
Thank you, Councilmember Gennaro. I'll turn it over to Councilmember Ressler for questions.
Great. Thank you so much, Chair. Similarly to my friend, Councilmember Gennaro, I couldn't understand what CCHR's position was on Intro 864. You support the intent of the bill.
Thank you for your question, Councilmember Ressler. So this bill, which would render unenforceable and void any and all agreements that shorten the statute of limitation for filing a case with the commission or with filing a complaint in court, we absolutely support the intent to prevent covered entities from using coercive contract terms that limit the time frame in which aggrieved parties can come forward for redress.
Yeah.
One thing,
we're just trying to understand your position on it.
So one thing that stood out to us about this bill is the potential legal hurdle of the retroactivity provision. So that is something that the administration is currently reviewing with the law department to understand its relationship in the context of state, federal law, constitutional law, contract law. So just noting the retroactivity piece. If I may, I'd also like to highlight a settlement that that the commission had with Fox News in June of 2020, which involved agreements that had forced arbitration provisions that in effect limited the ability of workers to come forward and seek redress for violations, and as part of the settlement, they could not include these provisions in employment agreements.
Okay, so the point of raising the Fox News settlement, it hasn't prevented any other employer from doing exactly that at some significant scale all across the city. So I think you would therefore agree that this law is urgent and necessary, correct?
We support the intent of the bill. Again, we're
apart
speaking.
From the retroactivity piece, do you support everything else in the legislation? Just yes or no, if you don't mind.
Again, we can't commit to saying yes or no without seeing the complete language of the bill, but we absolutely acknowledge and recognize the concern.
I have to say, I'm a pretty nice guy most of the time, despite what some people might say. But it is really darn frustrating for us to organize this hearing the day before the primary. We have a lot of things going on 4 days before the budget. This is a very busy time for the city council, and it's disrespectful to not be able to provide more direct answers to your positions on legislation. The point of these hearings is for the agencies to come before us and provide clear positions on where you stand on these bills. I'm asking questions very directly, and I'm not getting direct answers. So I don't see a babysitter from the mayor's office here. Forgive me if I missed, but I'm disappointed by the presentation today. I just want to state, so that it's clear, this legislation should absolutely apply to existing claims and existing contracts, because the purpose of this bill is to declare these agreements to be against public policy. They directly undermine the city's human rights law. When the New Jersey Supreme Court declared these contracts, reviewed this same issue, they declared these types of contracts to be against public policy, and that they applied to current contracts, and that they could apply retroactively. I don't understand how CCHR could come before us to testify a position that basically undermines the landmark law that you all care about. You say you support the intent of the law. Okay, so you support if we take out the retroactivity piece and just put it aside, which I strongly insist upon, but we put it aside for a second, do you support the remainder of the bill as drafted today?
I think we have said what we are prepared to say today. Any and all agreements is quite a broad scope for a law to cover. And we do spend a lot of time preparing for these hearings, and I'm sorry that we don't have a response that is satisfactory to you.
It appears to me, if you've been spending a lot of time preparing for these hearings, you prepared a long time to say very little. And there's an art to that. I've prepped people for these hearings over many years, but it's disappointing. And I hope you hear the frustration from multiple members of the committee today expressing our dissatisfaction with the lack of clarity on the administration's position. This isn't for fun. This is to understand where you stand on legislation so that we can chart a path forward. So I'm sorry to be frustrated, but I just, in the future, hope that we can get more direct answers from you all and other agencies, because this is not just a CCHR problem. This is an across-the-board problem where agencies come and testify and don't provide the information that we're requesting. So, thank you.
We've been joined by Public Advocate Jumaane Williams. I don't know if you want to do your opening remarks now. Councilmember Joseph, you okay? Okay, great. So we'll have the Public Advocate do his remarks on his bill.
Thank you so much. I appreciate it. Thank you, Chair Williams. Thank you, Councilmember, for allowing me to go. And from my understanding, it's been an interesting hearing so far. I just want to actually give an opening statement, which I appreciate you giving me an opportunity to do now. Afternoon, my name is Jumaane Williams, and I'm Public Advocate for the City of New York. I want to thank Chair Williams and the members of the Committee on Civil and Human Rights for holding this very important hearing. Intro 84 will require employers to hold an onboarding meeting to discuss an employee's reintegration back into the workplace after paternal leave. Having spoken to many of my staff who have welcomed children during their tenure in my office, and as a parent myself, I know the challenge of returning to the workplace. It is an adjustment not only for employees and their families, but for employers as well. Things shift quickly in the workplace. Policies can change and lapse. Public health emergencies necessitate rapid response, as we saw with the pandemic and the recent air quality issues. With this bill, we want to ensure that employees and employers can come together and facilitate an easy integration back into the workforce. It is customary for employees to write exit memos in anticipation of parental leave for work to be reassigned, but the same is not always true for their reintegration into the workplace. The policy this bill sets forth would ensure that employers are prepared to reassign previous or new workload to the employee upon their return. It also gives employees the space to discuss expectations as well as restraints and limitations throughout the transition period. Creating an inclusive and supportive workplace requires open lines of communication, and this bill formalizes one such instance when that kind of communication is most needed. This was originally a part of our Black maternal health package, but we know it has much further implications, so I'm hoping we can get support from the committee and, of course, the administration. Thank you so much. Appreciate it.
Thank you, Public Advocate. Do you have any questions?
I'll see what. Well, I don't know if. I'm hearing the administration may not be very supportive of many of the bills, so can I just find out, is the administration supportive of this bill? I haven't been able to read the testimony.
No, the administration is supports all the intent of the bills. I think the weeds of how they feel about the bill is what's coming into question.
Oh, okay. Is that correct?
I agree with that sentiment.
So what's the issue with the weeds of this particular bill?
Thank you, Public Advocate Williams. So to start, I would say there is an equity concern. This bill would provide a unique set of rights for parents returning from leave, that would not be required for other uses of leave, some of which are covered by the New York City Human Rights Law, such as leave related to disability and pregnancy. So again, just how this fits in the context of other sorts of protected leave that happen in the workplace. I'll also just highlight the Commission's role here. We do not administer any parental leave laws or enforce the application of parental leave in the workplace. Generally, the provision of parental leave in New York City workplaces stem from federal law, state law, voluntary employer policies. So that is, a concern as well. But we, of course, look forward to speaking with your office and working with City Council on, the best way to ensure that employees are made aware of their rights in the workplace.
So, just so I'm clear, are you saying that we should expand it so that we're covering more people on leave?
We're still in the process of reviewing the bill, and I will also point out that the Commission on Human Rights educating employees about their rights is included in our mission. So we already have notice of employee rights available for download on our website. We partake in multifaceted campaigns. We have legal guidance available. We have frequently asked questions on our website.
So this is something different, which I appreciate all those that are there, but this was specifically, it came up, and I just want to shout out particularly the black women in my office who brought black maternal health up as an issue. But this stemmed from that, but obviously I think it's far reaching from people who are going away who have children in any form. But I do know that there was an issue particularly with women who had children and came back. Their time that they spent could be the work that they put in before their career sometimes is step back because there's no proper reintegration. So I understand there's rights there already, but I'm talking about very specific to reintegration. Same way there's exit memos when they leave, something similar could be put in place when they come back. So, and I understand the rights that are already there. I'm talking about this one. Is this something that we should expand to include other folks? Because you mentioned something which is valid. People who may go out on disability may have some similar issues. So I just want to make sure this is something we should expand.
So just on that, I think that one piece would be to ensure that anyone returning from leave has access to the same rights as people who are returning from parental leave. So I think that's one piece. I think the other maybe piece of the puzzle is thinking about what are the mechanics for an agency, and in particular for CCHR. So in the current draft of the bill, I think we're charged with sort of setting out the agenda for a meeting that employers should have with staff. And I think one of the things we were talking about with enforcement earlier was, we cover the corner bodega and Google, the capacity of employers to be able to comply with some pieces of this depending on their circumstances. But also all of those companies are going to offer different things for their employees. And so I think there's a question, and this goes to sort of where leave laws stem from. We don't enforce any leave or administer any leave. So thinking about what is the right place for this to live, I think is an open question that we would probably like to discuss further with you and hear your thoughts on, as well as share some of ours. Because for the city is covered by our law, and we have a massive agency who does some of this stuff for the city workforce. There was DCAS just issued a leave primer, for example, for city employees. For the private sector, it's way more amorphous, and what leave people are offering is a choice for them.
And I'll wrap up.
Yeah.
I appreciate the time. But just so, what is your agency's connection to the leave laws that exist?
Just to make sure that if an employer is providing a certain type of leave, that all employees have access to that. So or reasonable accommodations.
You can, if this law passed, you can have a similar connection to a reintegration law. You can have a similar connection to a reintegration law that's associated with leave.
But those laws are not in our jurisdiction, so we're not the experts on those laws.
Okay. Thank you very much. And I have another bill that I'm co-sponsoring with Councilman Gennaro. And I'm not sure what happened, but I'm sure that I would like to align myself with the questions that he asked and the concerns that he put forth with that bill. Thank you so much. I appreciate it.
Thank you.
Thank you, Councilmember Joseph. Thank you for your patience.
No worries. Thank you so much. My question is around Intro 422, requiring covered entities to maintain a record of requests from persons requesting a reasonable accommodation. This bill would ensure that when employees receive a written request for reasonable accommodation, they keep a record of that request and make the record available to CCHR on request. So when enforcing HRL related to reasonable accommodations, has CCRH observed inaccurate records of requests for reasonable accommodations?
Thank you for your question. I think reasonable accommodations, when that comes up in a case, it can take place in a variety of ways, also depending on sophistication of employers. So I would say, short answer, yes, there can be challenges depending on, I mean, you have some employers who have a very, kind of regimented process. Then you have some where this will happen by word, a request might happen by word of mouth. Maybe the employer doesn't even know that what's happening is a reasonable accommodation request. Maybe the employee doesn't know that. So I think your question, went to how this works in investigations and if there's any challenges. And yes, it can come up in a variety of ways, in a variety of cases, depending on the circumstances.
So how do you handle those cases? What do you do in these cases when it does arrive on variety? It depends, because all needs are different. So what do you do?
I can't speak to any specific case examples, but or at least from specific investigations, but I do know that when the Law Enforcement Bureau is evaluating a complaint, a whole host of factors are taken into account. I mean, the more records available, the better, of course, but if there is no written record of the reasonable accommodation request, that doesn't mean that it's not actionable. And, sometimes if there's a lack of records, it will come down to, credibility of witnesses, but the Law Enforcement Bureau, handles it as the cases come.
Yeah, I think I'll just add to that, sort of similar to some of the conversations we were just having with the public advocate. We want to make sure we understand if this is meant to apply to all reasonable accommodation requests. And I know there are processes, again, for the city workforce where you document a request was made and the topic area and the outcome, and that's one potential model. I think there's some concern for all the reasons Ms. Scrivani mentioned around differential employers, some which have HR, some which don't, about the handling of sensitive information, medical records, and others that we are working through with the law department. But I think in general, we support the documentation of reasonable accommodation requests and the outcome. Not clear to us why the law is drafted, which would have it only for requests in writing, because again, that's usually, there might be a lot of things that happen orally in many, many workplaces, and so would love some insight into that to make sure that we're also treating employees and employers equitably.
Thank you.
Oh, and may I just also add that we do have in our law currently that employers, when they issue a determination on a reasonable accommodation request, first, when the employee is making the request, they're required to engage in a cooperative dialogue with the employee about the request. And then when the employer issues their determination, that is required to be in writing.
Okay, thank you. This bill would require that employees make records available to you, the request. Does CCHR currently have any problems accessing such records?
I think generally where they exist, the circumstances where our law enforcement bureau would seek those is in the context of an investigation, and we have the ability to request documents and even to subpoena documents. So it's the record keeping is helpful. I think we feel we have in our law enforcement mandate a fair leeway to access such records if they exist.
In the past, for refusal, you've gone as far as getting a subpoena. Is that correct?
In some cases, I can't say if those are unreasonable accommodation cases, but I can definitely look into that and get back to you.
Thank you. How does it impact a case? I'll rephrase that question. Are there some types of requests that are more likely to be documented compared to others?
Yes, also because the types of things that employers are permitted to seek are different depending on the basis for the request. So I think it's much less likely that we would have documentation in a request that relates to either domestic violence or sexual assault or stalking or religion, where there's not really a documentation requirement. With disability, there's a higher likelihood that there will be documentation, but it's not always required. And then with pregnancy and childbirth and related medical conditions, there's limited circumstances when an employer can ask for documentation. So that's sort of a more gray area than the other three.
Thank you. Chair, can I ask two more? Sure, thank you. So what kind of impact would the proposed legislation have on employers and employees?
I'm hoping there are employers and employees that are going to help us understand that landscape. I think, it puts a little bit of a burden on both sides, because if you're a potential covered employee, you're going to want to do everything in writing, and maybe you don't like to do that, maybe you do. For employers, obviously, there's a record-keeping, burden requirement. So I think it will lead to more files and more paper. One thing I can say from CCHR's perspective is I think it will increase the cases where there is documentation of the request for a reasonable accommodation, going to what my colleague was saying.
What changes, if any, would CCHR recommend to the proposed legislation?
So I think similar to sort of the comments we were making, I don't know if this is a required change, but one thing that we're exploring with the law department is what the ADA and privacy law have to say about what information can be both sort of maintained and then shared, and just thinking through what this law might require in those arenas. I think the other comment I already made was trying to understand and potentially think about the scope of a written request versus another type of request, if it would make sense for that to be covered. And then just thinking through, and some of this is like pounding the pavement to talk to different size employers and employees to understand how they understand this law. Reasonable accommodations is already a confusing concept, just a very legal concept. So how do we ensure that everyone knows that this obligation would now be on them?
And what enforcement challenges does CCHR foresees if the bill were passed?
I think as we read it, it wouldn't be a discriminatory practice under our law to not have the documentation, but I think that's an open question. Reasonable accommodations are some of the most frequent cases we see, so I feel like this is an extension of our work and wouldn't lead to any per se enforcement challenges other than identifying, what is the penalty for an employer if they don't do this, and then thinking through what it looks like to actually receive potentially thousands of pages of employer documentation of reasonable accommodations. But otherwise, I think it's squarely is something that would align with work we're already doing.
Thank you. Thank you, Chair.
You're welcome. I guess I'll attempt to ask some questions on the bill. So for Intro 84, this is on the Public Advocates Bill. Has CCHR ever received any complaints from employees alleging that they were not reintegrated into the workplace after a parental leave?
Thank you for that question. So since provision of parental leave is not a protected category under the law, we wouldn't have a complaint like that wouldn't be, or inquiry wouldn't be tracked. But what the city human rights law does have is caregiver discrimination. that is a protected category under the law. So we did have a case where an employee was using maternal leave, and while they were on leave, they were part of a kind of mass layoff in the workplace, but their position, they were the only one in their position that was laid off, and the allegation was for discrimination on the basis of pregnancy and as status of a caregiver. So when a discrimination in a protected category is related, if parental leave policy is related to that, then yes, it would be tracked, and that case settled.
I'm also just going to amend my response to Councilwoman Joseph, because I think I misstated that holding the records would not be an unlawful discriminatory practice. I think it would be under the law. Thanks.
Thanks. The next question that I will ask has to do with Intro 811, voiding no higher provisions in settlement agreements for persons aggrieved by unlawful discriminatory practices. Does CCHR come across cases where no higher provisions are included in settlement agreements?
Not that we're aware of from our conversations with our law enforcement bureau, but I can circle back and confirm that.
Okay, thank you.
Oh yes, but as Hillary is telling me, settlements don't often come to our office, so likely not.
Okay, if not, why do you think that is the case? Is it common practice to include such provisions in settlement agreements?
I don't have an answer to that question.
Okay. This is like general trying to understand, because you guys do implement various aspects of workplace human rights laws, and so in your expert observations or experiences, do you know why such provisions might be included in settlement agreements?
Yes, I think we likely, similar to some of the council members who have spoken already, understand that no rehire provisions would exclude someone in perpetuity from a position or ever applying for a job again. I mean, the council member referenced blacklisting. We are aware of that practice generally, but we don't have any specific knowledge more than that.
Okay. On 812, do you have any sense of what the impact of that law might be on New Yorkers? So this is the statute of limitations bill for commencing a private cause of action.
Yeah, I can imagine many potential outcomes. I am hoping that members of the public who bring these claims will also opine on the impact. I think there's a chance it could lead to more complaints and court cases being filed, but I think the open question that we sort of alluded to earlier is, will those cases lead to meaningful resolution for individuals who have experienced discrimination? And this is where the balancing of interests come into play. We know there's barriers to reporting, but we also know there's barriers to effective investigations, and trying to think of how those things can coexist.
Okay, on Intro 864, which is the forbidding of agreements to shorten the period in which claims and complaints of unlawful discriminatory practices, harassment, or violence can be filed, has CCHR encountered cases where such contracts of adhesion were incorporated from an application into an employment contract?
I'm not aware from the Law Enforcement Bureau of any cases that fit those exact factual circumstances, but I'll mention again that I think is related to this conversation are agreements at the outset of employment that require forced arbitration for violations under certain employment discrimination laws, and as part of the settlement with Fox News, which I'll mention was a sexual harassment and retaliation case, Fox News could no longer include in its agreements these forced arbitration clauses for the New York City human rights law for a period of 4 years.
Do you know how common it is for an employment contract to include such language? Are you aware of this being commonplace, or you don't know if it's common or not?
Yeah, it's the last one. We don't really have any information on how common it is.
Okay. Do my colleagues have any more questions? Okay. Thank you so much for your testimony and answering the questions. And we will call up the next panel of people. Thank you so much. And we look forward to getting this information back and working with you all to negotiate the bill so they can get passed.
Thank you.
Thank you. We're going to give the administration a few minutes to wrap up, and we'll be moving over to public testimony shortly. Thank you. We'll now turn to public testimony. I'd like to remind everyone that we will be calling individuals who are on Zoom one by one to testify, and you can begin when the sergeant has called the timer. Council members, if you have questions for particular online panelists, please let me know, and we'll call you after the panel has completed their testimony. For panelists who are here in person, once your name is called, please come up to the dais, and you can begin once everyone is situated. Just make sure you hit the microphone, the button, so the red lights are on. We would like to now welcome our first panel. We have Erica Vladimir, Gabriella Rendon, and Nina Shields. If they stepped out, they can come up when they're ready. You all can get started whenever you're ready.
Good afternoon, members of the New York City Council Committee on Civil and Human Rights. Thank you for the opportunity to provide our testimony today. My name is Gabriela Rendon. I am a staff attorney and community outreach coordinator at the Gender Equality Law Center. Here with me is my colleague, Nina Shields, legal intern at the Gender Equality Law Center. The Gender Equality Law Center's endorsement for passage of Intro 84. We believe the workplace onboarding meeting mandated by this bill will supply an efficient reintegration process for employees returning from parental leave. By discussing the goals, conditions, and expectations of employment, employers and employees can address any changes or updates that occur during the employee's leave. This will help employees understand their roles, responsibilities, and any modifications enabling them to transition back to work in a more seamless and effective way. This onboarding meeting can also be a check-in process for the returning employee to learn about rights related to being a working parent, including providing information about a parent's right to pump breast milk at work, a renewal and check-in about potential need for family leave in the future. For instance, it will be preferable for the employer to explain when any unused parental under the New York State Paid Family Leave and the Family Medical Leave Act can be taken and when such leaves of absence renew. Finally, at this meeting, assurances should be given to the employee that their leave will not be used against them in any adverse fashion going forward and since returning to work. For the aforementioned reasons, we endorse this legislation. However, we have some concerns about the execution of the onboarding meetings and whether they will be actually effective or more of a formality with no real impact. We have heard the many stories of our clients who have struggled to reintegrate into the workplace after parental leave. Many of them did not have any information about lactation accommodations or New York City paid safe and sick leave or about reasonable accommodation for childbirth-related medical needs. Others had no idea that they will be eligible for additional leave time after the passage of additional time, or that their job's duties could not change, or that they could not be evaluated on their job performance based on their absence from the workplace while on parental leave. Finally, many returning parents were unaware that they were still eligible for accrued vacation time even after taking New York State paid family leave. Because of this lack of knowledge, returning employees did not make these requests to which they were entitled because they were unaware of them or because they were afraid of making a request, thinking that they may be fired or seem as a difficult employee. Consequently, their return to work was overwhelming, difficult, and stressful. For such reasons, we strongly urge the City Council and the Commission on Human Rights to consider the following recommendations, especially while drafting the guidelines regarding the specifics of the proposed onboarding meetings. The onboarding meeting should include: 1, know your rights information about time and location for pumping under Local Law 185 and 186, as well as the Federal Pregnant Workers Fairness Act. 2, know your rights information about reasonable accommodation for childbirth-related medical needs, such as postpartum depression or mastitis. 3, know your rights information about job protection under New York State paid family leave policy. 4, a discussion of possible telework and flexible work hours and planning for work travel if needed. 5, a discussion about the employee's accrued personal time off and overall benefits. 6, a discussion of both the employer's and the employee's general expectations related to return from parental leave. 7, a clear statement made by the employer that the employee will not be penalized in evaluation bonuses, advancement, etc., because they took parental leave. 8, provide a copy to the employee of the subjects or topics discussed in the meeting. And 9, a discussion about a follow-up meeting to address or decide some of the requests or issues raised during the first onboarding meeting. The Gender Equality Law Center's endorsement for passage of Intro 422. This bill requires covered entity to keep a record of written requests for reasonable accommodations for at least 3 years. Ideally, this will help prevent misunderstandings or disputes regarding the nature of the accommodation requested and provide a level of protection for employees against potential discrimination or failure to provide reasonable accommodations. If an employer denies an accommodation request or fails to provide an appropriate accommodation, the employee can use the documented record as evidence to support their claim in potential legal proceedings.
Gabriella.
Oh, I'm sorry.
It's okay. No, you have a very lengthy testimony, and so if you can just sum it up in 30 seconds, that would be great.
So in regards to this intro, the 422, we support it. We think it's beneficial for not just the commission to have the information upon request to get to have the information about the written request for reasonable accommodation, but we also suggest if it's also available to the employee who made the request. Then in regards to Intro 811, the no rehire provisions, we support this bill too. We just have a suggestion in regards to small employers. We see it as maybe an impediment for some settlement negotiations or settlement agreements to occur. So if there's a possibility to carve out some ability for small employers to apply the no rehire provision as a option in settlement negotiations. And would you like to comment on the last two?
Sure, I can just sum up quickly for the last two. For Intro 812, we do support extending the statute of limitations to 6 years. We've had experience with employees, especially undocumented and non-English speaking workers, who don't know their rights until it's too late to bring an action under the current law, and also with individuals who experience trauma as a result of discrimination and harassment, have long-lasting effects, and it can take longer for the impact of that harm to become apparent to them and to recognize the extent of the damage that they've experienced. And so we support extending the statute of limitations. And then along with that, for Intro 864, we support this bill as well. We think that especially if extended to 6 years, the statute of limitations provides an important protection from employers imposing arbitrary restrictions that limit the ability of workers to seek redress for unlawful practices. And we've seen these kind of provisions happen, especially related to forced arbitration clauses, and employers have required employees to file a complaint in time periods significantly shorter than the city law, as well as like Title VII and state laws. And these can be inconspicuously included in like lengthy and complicated employment applications, and employees often don't even see them or understand what they mean until they've already agreed to them. So we support the passage of Intro 864, forbidding those agreements as well. And thank you, Council, for your time.
Good afternoon, Chair Williams and Councilmember Gennaro. My name is Erica Vladimir, and on behalf of the Sexual Harassment Working Group, I urge you to move Intros 811 and 812 out of committee so they can be considered for a full vote on the council floor. By a quick way of background, the Sexual Harassment Working Group is a workers' collective of former city and state legislative staffers who have experienced harassment, discrimination, abuse, and retaliation at the hands of elected and appointed officials. We've been working together in our unpaid free volunteer time since 2018, particularly on the state level, to enact stronger workplace protections against harassment and discrimination and stronger protections for those who are seeking justice after experiencing harm. You have my written testimony. I am going to update that because of some of the things that I have heard here from the Commission on Human Rights. But I do just want to take my next minute to sort of address some of the things that they said, specifically around Intro 811. They talked about balancing private interests. Well, I'm glad they consider private interests such as those of the employees who have actually experienced harm. All of the bills that the Sexual Harassment Working Group advocates for comes from lived experience, and that is exactly where Intro 811 comes from. Two of our co-founders were in a position where they had to go through settlement negotiations with an elected official who harassed and assaulted both of them during their work time with him. Their settlement agreement had no rehire clauses in them, not just for that specific office, but for the entire legislative body. These are people who commit themselves to public service, and most often a life of public service. And so to ban someone from an entire legislature, and if you think about from the private sector, take someone who works in finance. If you say, if they are having a settlement agreement with, let's say, Chase Bank, Chase is an international company. You are essentially banning them from an entire industry, and that highly goes against public policy. Just quickly on 812, extending the statute of limitations, as someone who has firsthand experienced sexual harassment by my employer, I can promise you that 10 years later, I know every single detail as to what happened to me. So sure, the ability to maybe document it from other witnesses, perhaps the abuser or alleged abuser themselves forget, but it is not that hard to document. Similar to what my colleagues here have said as well, it can take time to process trauma. This is why we have the Child Victims Act, the Adult Survivors Act. We need to give humans that ability to process what happened to them, to understand that what they went through actually was illegal, and other people might be fearful of retaliation and not realize that they have a claim or an opportunity to seek justice until, unfortunately, other victims come forward publicly. But we should allow that time. One other nuanced argument that I've also heard is that, harassment and discrimination at the hands of your employer is a violation of your work contract. And a work contract, or to bring a suit against a violation of a contract, is 6 years statute of limitations. So I'll just stop there and thank you very much.
You're welcome. Do you have a question? Councilmember Gennaro?
Yes, I want to thank you, Ms. Vladimir. It's been great to work with you and the Sexual Harassment Working Group to to craft 811 and 812, and certainly they should have gotten more attention from the Human Rights Commission, but we'll work on that. And you covered most of the points, and but with regard to the statute of limitations from 3 to 6 years, so we just expand upon that just a little bit more, because I think people are going to get a little hung up on that. And even though you said a little bit about it, I think that more on the record the better. If you could speak to that.
Sure, thank you, Council Member. I will speak again from my personal experience. I was sexually harassed by my employer in 2013. And after speaking privately to a few people, the ultimate decision was either suck it up and not tell anybody, or to move on and leave. And so I chose to leave and really just keep my mouth shut and not share it with anyone. And I thought that I had moved on. It took 3 years later for me to realize how much it actually had an impact on me, and what it meant to stay quiet and the potential harm I might have put future employees in. And that is when I chose to speak out publicly. Now, I have chosen not to move forward with a civil claim, but I know many people in my position who it took them a few years to come forward, and from there to realize that they have a right to justice that was taken away from them. Sometimes it looks like the ability to sue and have funds to go to therapy. We know therapy is really expensive and most often not covered by health insurance. Or for lost wages. Someone who has a gap in their work experience because they left, they might have economic damages, lost wages that they're not able to recoup, even if they, let's say they chose to change industries. They deserve that type of justice, and it takes a long time to process. Choosing to go forward with a lawsuit is a very big decision. It puts a victim in an entirely new but re-traumatizing, vulnerable position. And it's not a type of decision that can be made just overnight. It's not something you just sleep on one night. Finding an attorney who will be willing to take your case, that can also take a lot of time because these can be difficult cases. And then these cases can drag on for years. I'm in the middle of a state ethics agency complaint process, and that has been taking over 5 years. So imagine just going to New York Supreme Court and having to go through that. Victims are human beings, and human beings don't process things like computers. And so we have to give them the time, and it is good public policy to expand the statute of limitations.
Thank you very much, Ms. Vladimir, for your very compelling testimony, bearing personal witness, coming out the way you have, and working with me in my office and with the council in order to bring redress to for those who have suffered and to prevent other people from going through what you and many others have. So I thank you for your very compelling testimony, and that concludes my questions. Thank you, Madam Chair.
Thank you so much, Chair Williams, and thank you, Erica, for your leadership and work in the Sexual Harassment Working Group. I just really want to say thank you to each of the people who's been involved in it over the years. Many friends, people who have experienced just totally unacceptable workplace dynamics in city government and state government, and I am deeply appreciative of the sustained advocacy over an extended period of time. Appreciate you working so closely with Councilmember Gennaro on Intros 811 and 812, which are great bills. Was wondering if you all had a position on the legislation that we've sponsored today, 864.
Thank you, Council Member, and thank you for your support of the Sexual Harassment Working Group, basically since our inception. I will say we formally have not taken a position on any other bills, but I will say in my personal capacity, I do support that bill and think it complements nicely Intro 812.
Thank you so much for your testimony.
Thank you. The next panel we will be calling will be via Zoom. We have Dana Bolger followed by Miriam Clark. Dana, you can go ahead when the sergeants call time.
Starting time.
Good afternoon, and thank you for the opportunity to testify. My name is Dana Bolger, and I'm a staff attorney at A Better Balance. ABB is a national legal services and advocacy organization headquartered in New York City that has championed efforts to pass key provisions of the city's human rights law, including the right to reasonable accommodations for pregnant workers and the non-discrimination protections for caregivers. Through our free and confidential legal helpline, we hear from thousands of New Yorkers, especially low-wage workers, who rely on these new protections. But rights on paper are only as good as their enforcement. Many of the workers we hear from depend on public enforcement by the Commission because they cannot afford to hire private attorneys. Over the last several years, the Commission's funding and staffing levels have fallen to unconscionable levels with dire impacts for workers. In fiscal year 2022, workers had to wait an average of nearly 2 years for the commission to complete its initial investigation, and often far longer for their case to be conciliated or prosecuted. Under these conditions, we cannot in good conscience recommend that workers file with the commission. So we urge the council to increase funding significantly and without delay. We strongly support Intro 422, which would require employers to maintain a written record of accommodations requested under the Human Rights Law's cooperative dialogue process. On our helpline, we have seen what a huge impact a robust cooperative dialogue can make. It can literally be the difference between a worker being able to get the accommodations they need to remain in the workplace and losing their livelihood, health insurance, and even housing at the moment they need those things the most. Our written testimony outlines several changes that we strongly recommend the council make to further clarify and strengthen the bill, which again, we support. We also strongly support Intro 811, which would void no rehire provisions in settlement agreements for workers who have experienced unlawful discrimination. Employers often use these no rehire terms in concentrated industries heavily dominated by only a small handful of employers, forcing low-wage workers to abandon professions they've worked in for decades. For example, one low-wage worker who contacted our helpline after experiencing egregious sexual harassment and pregnancy discrimination was forced to sign a no rehire settlement clause, leaving her no option but to leave the industry that she had trained and worked in for many years. We also strongly support Intro 864, which would void private agreements to shorten workers' statute of limitations to file claims under the human rights law. Like the no rehire provisions, these agreements are a way that employers weaponize contract law to circumvent the council's democratic enactment of anti-discrimination laws. And finally, we urge passage of Intro 812, which would extend the statute of limitations under the human rights law to allow workers the time that they need to pursue their claims. The low-wage workers we hear from on our helpline often do not realize immediately that their rights have been violated or fear retaliation for asserting their rights. So again, we urge the bill's swift passage. Thank you for the opportunity to testify today.
Thanks. Have you seen those provisions and settlements on your end? You're muted.
We'll unmute her in a minute. You gonna mute?
Thank you for unmuting me. We absolutely have. Just recently, we had a worker who was forced to sign a no rehire provision, and as a result, likely will have to leave the industry she's worked in because it's dominated by only a couple employers in the city.
Are you able to estimate how many of these cases take place? Like how many of these, like there's no way to tell, like from your experience, how many times have you encountered this?
It's certainly something that we see, and I'd be happy to look into getting you a number after the hearing.
Okay, thanks for your testimony.
Thank you. Next we have Miriam Clark. You can go ahead when the sergeants call time.
Time starts now.
Thank you. Thank you very much for the opportunity to testify here today. My name is Miriam Clark. I'm a partner in the law firm of Ritz Clark in Ben Asher, where I've been representing employees for more than 35 years. I'm also a former president of NELA New York and chair of NELA New York's legislative committee. NELA is a national organization of attorneys dedicated to vindicating employees' rights, and NELA New York is New York State's affiliate, and we have about 350 members statewide. I'm testifying in support of Intro 811, banning employers from forcing survivors of employment discrimination to enter into what we call do not darken my door clauses. As you've heard, these clauses bar employees from ever applying to work for or their former employers again, or even any remotely related entities. As you've heard, as a result of these clauses, many survivors settle their cases and then find themselves barred from employment in large swaths of the job market. Most of the time, these clauses have no expiration date, so an employee who signs such an agreement early in her career is still bound by it 20, 30, 40 years later. I just want to deviate from my written testimony to say, in response to Councilmember Williams's question earlier, I see these clauses all the time, including in cases that I settle in front of the City Commission of Human Rights. So if you have a mediation at the City Commission of Human Rights, there's often a private settlement agreement that the commission is not aware of. And I've had do not darken my door clauses forced upon my clients in those cases. I would say that at least half the time, employers try to put these clauses in agreements, and often my clients really don't have the leverage to reject them. So as an example, as Erica testified earlier, I had an employee who settled a claim with a large New York City bank. The do not darken my door clause applied not only to that bank, not only to that bank, but its successors and affiliates. Had the client signed the agreement, she would have been locked out of her whole field. So employers sometimes argue that these clauses are necessary to deter survivors from reapplying and then bringing retaliation claims if their applications are denied. Employers do not need these clauses in order to turn down unqualified applicants. We also heard that the City Commission has some concerns about whether these clauses would be necessary if there was disciplinary misconduct, for example. But again, an employer can always turn someone down for legitimate reasons, such as documented misconduct. As a matter of public policy, we often hear that we want to encourage settlement of these claims, but employers who demand do not rehire clauses are engaging the opposite behavior. They're discouraging settlement and encouraging litigation. No rehire clauses are unlawful in Vermont, in Oregon, and in California. They're disfavored by federal courts who evaluate settlements under the Fair Labor Standards Act, who reject them as highly restrictive and in strong tension with the remedial purposes of the FLSA. We urge the New York City Council to pass 811 and end the unnecessary punishment of those cases. Yes.
Hi, are you almost done?
I'm done.
Oh, great. Okay, I had a quick question, and you can quickly respond, around the cases that you mentioned that you settled in front of CCHR. Do you have a little bit more information on that? How many cases did you settle in front of CCHR that included these no rehire provisions?
I don't have, I can't tell you quantifiably, but I just looked up a recent case that I settled in front of CCHR, and there it was.
When was that?
A year and a half ago.
Okay. Anybody else? Okay, thank you so much.
Thank you.
Thank you. We'll call the next panel. We have Doria Kirabate, Ann L. Clark, and Jessica Walker.
Do you have any documents?
Yes. Thank you.
All right. Thank you.
You can get started whenever you're ready.
Good afternoon, and thank you for convening this critical hearing that examines expanding New York City human rights law employment protections against workforce discrimination. My name is Doria Kirabate, and I am a staff attorney at Legal Momentum, the Women's Legal Defense and Education Fund. For over 5 decades, Legal Momentum has been at the forefront of using the law to advance gender equality for women in the workplace. I'm testifying today in support of Intro 811, which would eliminate a long-standing retaliatory practice in settlement agreements used by employers that effectively penalize employees who challenge workplace discrimination. Representing women in gender discrimination actions, we have seen firsthand the leverage that employers hold, the hardships that women encounter in challenging discrimination, and the re-victimization they face when confronted with punitive settlement terms. For example, we represented a client who challenged workplace sexual harassment and was forced to leave her nonprofit job because her employer refused to dismiss the volunteer who was responsible for the harassment. She settled the case and was strong-armed into accepting a no rehire provision. While we were successful in narrowing the scope of this clause, it nonetheless served to limit her career options going forward, particularly as an employee with unique expertise in a small field with limited opportunities. These kinds of outcomes cannot be allowed to persist. Legal Momentum also supports Intro 422, 812, and 864, which collectively advance workplace protections, particularly for women and people of color. I want to close by recognizing New York City's commitment to addressing discrimination in the workplace. These bills would help employees overcome longstanding barriers to workforce discrimination. Thank you for the opportunity to share our thoughts and for your attention on this issue. We hope you will continue to rely on us as a resource going forward. Thank you.
Hi, good afternoon. Thank you for the opportunity to testify this afternoon. I'm Ann Clark. I'm the managing partner of Vladeck, Raskin & Clark, where I've represented employees for 30 years. I'm also a member of the Legislative Committee of the National Employment Lawyers Association, the New York affiliate. I'm here to support Intro 864, an important bill to prevent employers from circumventing New York City's robust laws against discrimination. As part of a carefully constructed law to advance those strong public policies, the New York City Human Rights Law provides aggrieved people 3 years to file in court, 3 years to file claims of gender-based harassment with the City Commission on Human Rights, and 1 year to file all other claims with the City Commission. And the Council, I'm pleased to see, is currently considering extending the period to file in court to 6 years. However, we've discovered that some employers require employees to sign contracts of adhesion that significantly shorten those limitation periods. Several large employers mandate limitation periods of only 6 months. And it'd be bad enough if these contracts merely made it more difficult for employees to vindicate their rights, but people often don't realize that they've signed one of these agreements that are often hidden in things like in employment applications. Even a sophisticated employee is unlikely to remember what they signed or even checked off on a box online. They and their lawyers believe they have a much longer period of time to file claims and are likely to miss the shortened deadline entirely. In essence, these employers are trying to write themselves out of the civil rights law. The public policies recognized by the City Council should bar enforcement of these contractual limitations for claims under the New York City Human Rights Law. Unfortunately, in New York, courts have not stepped in to strike down these provisions. The first case in which a New York intermediate appellate court ruled on it, they looked only at breach of contract claims in the business setting and said it was permissible. They did not address this strong public policy, and I'll try to summarize the rest of my testimony quickly. In New Jersey, as Councilmember Ressler mentioned, there's a much better result. The New Jersey Supreme Court recognized in Rodriguez versus Raymores Furniture that these provisions violate the strong public policies underlying the New Jersey law against discrimination, which all apply in equal force to the city human rights law. I want to talk briefly, if I could, just about the practical issues with this. A 3-year statute of limitations and hopefully soon a 6-year one is important for people to be able to vindicate their rights. People don't always realize they've been discriminated against. If they do, they might not know how to find an attorney or otherwise pursue an action. They might be dealing with trying to find a new job or trauma or the pregnancy or disability or domestic violence that's at the heart of their case. In addition, while 3 years is not sufficient time, or is the minimum sufficient time if someone's going to bring a claim for being dismissed, very often when someone comes to me, they've been fired and finally decided to come to a lawyer, but there have been years of other discriminatory acts that led up to it. They were passed over for promotions, they were demoted, but at the time they didn't want to put their job at risk by rocking the boat and certainly by filing an action against their employer. If they come to me after they've been fired, we can cover not only the firing, but we can reach back to all the things that led up to that termination. And even after somebody finds an attorney, having more time to file in court is important because, of course, it's always better if the parties can work out an informal resolution, and you can't do that if you have to rush into court. It doesn't give employers time to look into issues raised by attorneys that contact them. It doesn't give people like me sufficient time to thoroughly investigate claims before filing in court. But most importantly is that most people don't know about these. So what prompted me to reach out to my council member is a year ago, I had this issue. In early 2020, a man came to me with an age discrimination claim and had already spent a few months trying to resolve it internally with his employer. He was sophisticated and educated. He had an MBA. He had no recollection that when he filled in his online application, there was a box he checked that apparently limited his statute of limitations to file in court in 6 months. I hadn't dealt with this employer before, so I thought we had the usual time period. We filed in court just over a year after he was fired, after exhausting some requirements for his federal claims. Later, the employer argued that because of this online application, all of his claims, including his city human rights law claim, should be dismissed. Luckily for us, the court found that that employer waited too late to raise the issue, but could have thrown out very valid claims because of an application he signed and had, standard language that he knew nothing about. So we think it's essential that the City Council pass Intro 864, not only to allow people sufficient time to vindicate their rights, but so that employers cannot write themselves out of the civil rights statutes.
Thank you. You have a question again?
Thank you so much, Ms. Clark. Really appreciate you reaching out to us and working with my team, especially Molly Haley, who I don't say enough is terrific.
She is.
She is terrific. We can all agree. I'm very lucky to have just an absolutely brilliant person driving our policy and legislative agenda. But we really appreciate you bringing this idea to us and calling it to our attention. The issue that seems to be the greatest rub is issue of retroactivity from CCHR and the law department's perspective. Could you explain why you think it's so important that we ensure that Interest 864 is passed as drafted to apply to current contracts and apply retroactively, and how it's worked in New Jersey?
Absolutely. What Intro 864 is doing is not creating some new right that employers now have to make sure that they comply with. If you're adding a different category of protection, employers have to be on notice before they can start altering their behavior. These contracts of adhesion are really attempts to get out from under the existing structure of the city human rights law. So this is just saying that these violate public policy. These are contrary to what already exists in the city human rights law, which has carefully thought out statutes of limitations, and really shouldn't be any different than when the New Jersey Supreme Court looked at it in the Rodriguez case. They said this is unenforceable and threw out an existing contract for the, it was also an application for a Raymores and Flanagan employee, and said it can't apply in the future, but also struck down that existing provision. Because they are buried in things like employment applications or the mound of paperwork people get on their first day of employment, someone could sign one of these and not experience discrimination until 10 years later, and the employer could still be seeking to use that to deny somebody their ability to go to court at a much later date. So this is not creating some new landscape. This is just saying that for these employers that try to get creative, you have to abide by the law as it is written.
Thank you. Similar to the question I asked the other panels, do you have a sense of the number of cases, even for the situation with people who might be signing these documents, not knowing that they're limiting their ability to file a complaint down the line? Do you have a sense of whether or not it's commonplace? Because I think CCHR around some of these, they couldn't really describe whether or not it's a commonplace, whether or not they're seeing it a lot. So from your industry experience, do you see that a lot where there's a whole bunch of no hire provisions? Are you seeing where many of your clients unfortunately might have signed something that prohibits them from filing any claims?
I was lucky to not encounter it until recently, but based on the cases that are out there, it is something that, unless they've stopped recently, Federal Express was doing. Raymore and Flanagan, both the New York case saying that the provision was fine and the New Jersey case striking it down involved Raymore and Flanagan, and Northwell Health, which is the largest private employer in the entire state of New York, has this in their applications. And while I'm not here to testify about 811, I will tell you that as somebody who settles cases all the time, I would say, Miriam said more than half, I would say way more than half have a provision saying you will never apply to work for us again. And we try to negotiate them out or down, but if somebody really wants or needs that money at that time, they're going to sign it. And we've all seen how many hospitals were there when I started and how many are there now in New York. Banks. The first trial I had was somebody who worked for Manufacturers Hanover. I don't know if anybody here is old enough to even remember that. When it merged with Chemical Bank, he lost his job, and by the time we went to trial, it was Chase Manhattan Bank, which is now JP Morgan Chase. So if he'd signed something that said he wouldn't reapply to Manufacturers Hanover if he'd settled instead of going through all this litigation, he couldn't work for, JP Morgan Chase, one of the largest financial institutions in New York City.
Yeah, and I agree. Just to add on to that, in our experience in our settlement agreement, this was a huge international organization, and they had told us that they do not settle without a no rehire clause. So this is something that they practice.
So it's fair to say it is a common practice around various settlements.
Yeah, I don't have the luxury of tracking things, but I would say at least 75% of settlement agreements have such a provision.
Okay, thank you so much.
Yeah. Thank you.
And just reminding the next panelists and whoever is coming after to try to stick on the topic of workplace discrimination. Not you, this is for a future, you guys are done. Thank you. To stick on the topic of workplace discrimination and try to respect the decorum of the committee hearing. And I'll turn it to Jaysuri to announce the next panel.
Thank you, Councilmember. Next, we have Tawaki Komatsu, Dontarius Igbam, and Alex Stein. You can come up and testify whenever you're ready.
Sorry. I guess what I'm looking at are people that are part of this committee. But despite that fact, there are people that were in this room previously. I was the first person in this room at the start of the hearing, and I'm the last person to testify. So with regards to procedural due process rights, this is a public hearing, but there's an empty seat over there where Mr. Salamanca was. Mr. Gennaro, I don't see him. And Mr. Ressler, I was looking at you playing with your phone for much of the hearing instead of paying proper attention to the people that were testifying. So with regards to a comment that Mr. Gennaro made earlier during the hearing, that people who testified prior to me, they weren't prepared to provide people like you with the relevant information. If you're staring at your cell phone, why would that be relevant? Meaning if you're not paying attention to their testimony, what is the basis for that objection? With regards to today's hearing, however, it's about bills that you've proposed to try to make it easier for workers to assert their legal rights in litigation. But again, if people like me come to this public hearing, are the first person who walked through the door and are the last person to testify, while people that are part of your team are not even in the room, how productive is that? Also, with regards to today's agenda for today's hearing, yesterday I mailed a petition for rehearing to the U.S. Supreme Court about one of the matters that is part of today's agenda, meaning if someone discriminates against you, you have a certain timetable to pursue litigation. I've done that. Problem is when you get to the court, some of the judges don't even look at your legal papers, meaning at the New York City Civil Court, 2 judges issued orders which lifted the stay in litigation of mine. However, in related litigation, Judge Alexander Tisch, he lied. He basically said there's a stay still in effect. So the point is, I should also point out that the city of New York, they do business with a company that stole my pay in 2012. So the city of New York actually has a level of influence that it could exert on a company that's still subjecting me to wage theft to basically make a policy decision that, you know what, we're not going to do business with this company until you pay this worker for wages that he earned 10 years ago. So last point really is this, in terms of protected classes, some of the protected classes that aren't such include protected First Amendment activity, meaning if I file a valid lawsuit and because of filing that valid lawsuit, I can't get a job interview with a city agency, can you modify New York City's human rights law to add a protected class for people who engage in protected First Amendment activity, whether it's criticizing a council member who chooses not to be in the room during a public hearing, filing a lawsuit against a city agency that commits fraud against somebody. So that if the person who files that lawsuit then tries to get a job with a city agency, he or she is not being granted a job interview strictly because they filed entirely valid litigation. So what I would like to see out of this hearing essentially is to have your team approach that with an open mind to see, you know what, yeah, there actually should be an expansion of the protected classes such that protected First Amendment activity would be part of
testimony, sir.
I'm sorry, but with all due respect, when other people were testifying and that
I
expired.
was going to tell you, you can wrap up. So go ahead, you can wrap up.
Okay, so last point really is this.
I think I told other people to wrap up too when they went.
You didn't. The first person who testified during today's public hearing.
You went over, but the rest of the people I did tell them to wrap. So go ahead, wrap up.
So last point is this. U.S. Federal Judge Edgardo Ramos gave me an extension of time to submit a motion to him about why he should change his mind about ongoing litigation of mine pertaining to the issue of people coming to a public hearing, trying to speak their mind, while people in front of them basically aren't in the room, don't give them the time of day in regards to what they have to say. So like I said, Mr. Ressler, he was on his phone for much of today's hearing. He talked about how there's a primary tomorrow. But in terms of a performance evaluation, meaning if people come to a public hearing, they're testifying to people who they expect will give them the time of day, proper consideration. But when people in the audience are looking at a council member playing with their cell phone, the natural conclusion is, no, they're not doing that. Anyway, have a good day.
Thank you so much for your testimony. Have a great day. All right, do we have anybody else testifying? Oh, great. Well, this committee hearing is closed. Thank you so much.